Well, basically to have a case for age discrimination, there's certain elements that are necessary.
Right.
You have to be in the protected class, meaning over the age of 40. You have to have been satisfactorily doing your job. And you have to have a adverse action, employment action against you, generally termination of your employment. And then you have to either have been replaced by a younger person, had your job duties distributed to another person, or show direct evidence of age discrimination. And then the employee has to then show that the legitimate non-discriminatory reason articulated by the company is false. And if we don't have discriminatory statements made by decision makers, the way we prove discrimination is circumstantially by proving that the reason given is false. The United States Supreme Court has said that the jury can infer from that false pretextual reason that it was being used to cover a discriminatory reason. So once we can show that the reason given by the company is bogus, then we have a chance of prevailing. The jury still has to decide that it's age discrimination. It's not automatic. They can't, simply because we prove that the reason given by the company is false, does not in and of itself mean there was age discrimination. The jury still has to believe that there was age discrimination, but pretty much that's what we're usually stuck with, because very few managers say we're getting rid of the older people.
Well, actually, some courts have come right out and said that saying something like, oh, you're overqualified, is a euphemism for you're too old. It's a way of tactfully telling someone that, that they're too old. Another thing is, typically when you say someone is overqualified, there's someone that's young, straight out of school, and the reason you don't want to hire them for being overqualified is that they will soon go to another job for which they are qualified. When you're talking about an older person, that logic doesn't really hold true. So to tell an older person that they're overqualified and they don't want this job is not only condescending, but the logic really doesn't hold water. We're talking about whether it's okay for a company to, rather than say you're too old, say you're too overqualified. And it's not okay if it's age discrimination, but whether it constitutes age discrimination under the statutes is the big question. Under the ADEA, there are two general types of cases. One is disparate treatment, and one is disparate impact. In a disparate treatment case, those are much easier to litigate. A disparate treatment case is where someone is out and out treated in a disparate manner because of their age. So for example, and this would be an obvious example, but if the company said no one is allowed to work here past the age of 50, that's very obvious disparate treatment. That would be the basis for a lawsuit. Disparate impact is where the company has a policy that applies to everyone equally, but it has a different effect on different age groups. And this would be what you're talking about. For example, if they say we're no longer going to hire anyone with more than 20 years of experience. Well, that applies equally to everyone. They're not applying one policy to just one group of people. But obviously, it's going to have a disparate impact on older people. So the disparate impact cases are much more difficult to win. And some courts, including the United States Supreme Court, have suggested that if there is a disparate impact and it was not motivated by stereotypes about older people, then there is no claim under the ADEA for age discrimination.
People in their 50s are more likely to see an attorney because they have kids in college, they've got a lifestyle going, they've been with a company for a long time, and it's hard for them to get a new job. People that are younger, even though they may be over 40, they may go and find a job right away, and so they don't have much to complain about. In age discrimination, unlike other types of discrimination. Age discrimination has its own law, the ADEA. And the remedies available under the ADEA are solely wage loss. You can get what's called a liquidated damages doubling of the back pay if you can show that it was a willful age discrimination, but you're not entitled to recover for your emotional distress, for punitive damages. And so people that go and find a new job right away really don't have any damages, so to speak, if they find one that pays the same. If they find one that pays less, then they have damages of the difference. But it's a wage claim, basically. And people that are filing under Title VII for gender or race or religious discrimination, they can also recover punitive damages, but they're capped. But they have an opportunity to recover for the emotional distress that they suffer.
I think that probably the biggest reason that people feel more discouragement at being let go rather than not being hired is that when you're let go, you know you have a better understanding of being let go from a company you've worked for, and a better understanding that it was likely because of your age. When you don't actually get a job, it could be for many reasons, and I think it might be easier to maybe write off in your mind. Additionally, there's a lot of people who've been with companies for such a long time, they feel and they felt that there was a certain amount of mutual loyalty there. And so when they're suddenly dumped by the company, it's their whole life's livelihood, it's their whole plan, it's their whole everything. And that creates a real sense of betrayal after having felt like they gave their life and loyalty to a company.